This is from Freedom Outpost, April 6th, 2018, from Suzanne Hamner. It's time to talk about ex post facto laws and resistance to tyranny. Now, I made a video the other day on this, but I thought I'd better expand this. It says, to get a better understanding of ex post facto law, Publius Huda has an excellent piece covering it on her website. An ex post facto law retroactively criminalizes conduct that was not criminal when it was done. Okay? Now, how does this apply to the village of Deerfield, Illinois, and all these other things? According to Article 1, Section 9, Paragraph 3 of the Constitution of the United States of America, no bill of attainder or ex post facto law shall be passed. While this pertains to the Congress, there's a provision in Article 10, or Section 10, Article 1, Section 10, of Paragraph 1. It says, of the Constitution of the United States of America, no state shall enter into any treaty, alliance, or confederation, grant marks or letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver, a tender in payment of debts, pass any bill of attainder, ex post facto law, or any law impairing the obligation of contracts or grants of any title of nobility. Okay? Okay, now, Alexander Hamilton, writing in the Federalist Papers, number 84, fourth paragraph. The creation of crimes after the commission of the fact, or in other words, the subjecting of men to punishment for things which, when were done, were no breaches of law, and the practice of arbitrary imprisonment have been in all ages a favorite, most formidable instrument of tyranny. There's no way the Founding Fathers would ever think of allowing towns or the Congress to infringe upon God-given and inalienable rights if the states and federal government are prohibited from doing so. Now, these kinds of infringements are happening all over the Republic, including legislation introduced by Congress banning certain types of weapons. While weapons already in possession of the citizens are not affected by some legislation, including that introduced into Congress, they're only testing the waters to see how American citizens will respond to the infringement upon their God-given, unalienable rights to keep and bear arms. Let's see. It's going to come to a problem here. Some people in towns, villages, municipalities, and cities that have or are trying to enact such unconstitutional ex post facto law have a choice: comply, resist, or leave. Those who cannot leave either comply or resist. It's a choice that you have to make. There's no co-op that we don't have a choice. It may be one that is liked, but it is a choice. It won't be long before many of us in this republic will be making that choice, since more and more states, towns, and counties will seek to infringe upon the Second Amendment. Congress is working it as well. Unfortunately, citizens may have to choose between yellow snow or red snow. There won't be a middle ground. Now is the time to put this to rest by standing up to resistance. If not, prepare to kneel in enslavement and submission. No longer can citizens solely rely on the NRA, or the Gun Owners of America to engage in this fight. It's going to take all citizens in support of the God-given, individual, unalienable right to keep and bear arms to quell this squall. Now this, where is this, where this woman, okay, this Suzanne Hamner, it's her pen name. She's a registered nurse, grandmother of 4, a political independent residing in the state of Georgia who is trying to mobilize the Christian community in her area to stand up and speak out against tyrannical government, invasion by totalitarian political systems masquerading as religion, and get back to the basics of education. Okay. Now, I brought this thing up about the ex post facto law for they passed that Lautenberg Act in 1996. Said if you have been convicted of domestic dispute or whatever, you weren't allowed to have a firearm. Okay, you had all these people in the 1930s, and the 1940s, the 1950s, the 1960s, the 1970s, the 1980s, and even the middle of 1990 that probably fall underneath this so-called law. But they never broke the law. There might have been a domestic dispute, and it's always been that way since mankind. But you cannot pass a law retroactively. It goes all the way back to Adam and Eve. It's against the Constitution. Those people were never denied their gun rights. From all the people I said, like from the 1930s to the mid-1990s, they still went to the gun store, they bought firearms, and they filled out all the paperwork, and it was perfectly legal for these people to have those firearms. Now this brings up another point here. Since the Lautenberg Act of 1996 is unconstitutional, is therefore null and void. So anybody ever convicted under that law, afterwards, they're free and clear. It's a law. It has the color of law, but it's not legal. That's where I'm getting at. We're going to go over here just a second. Just a second. I want you to see what I'm talking about here. Zoom this in. These are ex post fact. This is from Black's Law Dictionary. Okay, 6th edition. Okay, it's a law passed after the occurrence of a fact or commission of an act which retrospectively changes the legal consequences or relations of such fact or deed. A law is unconstitutional if it's ex post facto, because it deprives the defendant of a defense to criminal liability they had prior to enactment. Okay, let's go over here just a little bit more. Okay. An ex post facto law is defined as a law which provides for the infliction of punishment upon a person for an act done when it was committed, whether he was innocent or not. A law which aggravates a crime to make it greater than when it was committed. A law that changes a punishment or inflicts a greater punishment than the law annexed to the crime when it was committed. A law that changes the rules of evidence and receives less of a different testimony than was required at the time of the commission of the offense in order to convict the offender. A law which, assuming to regulate civil rights and remedies only in effect, imposes a penalty or deprivation of a right which, when was done, was lawful. A law which deprives people accused of a crime some lawful protection to which they have been entitled, such as the protection of a former conviction or acquittal, or they got amnesty. Every law which, in relation to the offense or its consequences, alters the situation of a person to his disadvantage. Interesting. So like I said, all these people convicted under these so-called laws of these domestic violence, you were perfectly allowed to have the firearms that you bought before the 1996 ex post facto law called the Lautenberg Act. Violence against women. They're always putting men at a disadvantage. They're just using this as an excuse to take away firearms from the people. You know, there are laws on the books called stalking, and that the government tends to use that a lot, you know, when they want to put somebody away. And stalking is usually because you're obsessed with something. Now, if you look at what Congress has been doing for the last 40 years, they are obsessed with getting rid of the Second Amendment. They are obsessed with destroying the Constitution of the United States. They are stalking the Constitution of the United States. They should be put in jail. Like I said here, for every law which in relation to the offense or its consequences alters the situation of a person to his disadvantage. And that's over, that finishes it there. So, start standing up for your rights. We've got to get these anti-gun, anti-American people out of office. We have no business having these socialists in there since FDR was in there, and he started that law on the 1934 law that they put under the Internal Revenue Code. Now remember, in the Constitution it says, for the security of its free state, hang on, I want to make I get this. I go through this so many times, I tend to get all my words mixed up. Sometimes I try to hurry through this, and it's not a good thing. When you hurry through something, then you mess up. A well-regulated militia, being necessary to the security of our free state, the right of the people to keep and bear arms shall not be infringed. Okay? These are the amendments. Here's your second one. And you said, see there, it says, shall not be infringed. Now, do you see any sub-paragraphs like A, B, C, D that might stipulate when an acceptable infringement might be? There are none. Therefore, no infringements are allowed. They are forbidden. They are not allowed to mess around with your Constitution. All these gun laws that they wrote, they put them underneath either the Internal Revenue Clause or into the Commerce Clause, which is only to stop the states from taxing and adding tariffs to things and stop the politicians from padding their pockets. It's to keep the free flow of goods flowing through the states, and that's all the Commerce Clause was. It wasn't meant to support any firearm bills or anything like that. Your Constitution is the law of the land. Get these people out of office. If they don't understand it, if your Supreme Court doesn't understand it, well, they got a problem. They've got to go by the original intent. They have to look at your Declaration of Independence. They have to look at all the Federalist Papers ever written, because the Constitution was finally ratified in 1791. The Federalist Papers come out before that. Let's see. You've got to watch out too, because most of these people, just like your people in Congress that are making these laws, they don't understand the Constitution, they don't understand law. We've got to be on the lookout, because one of the things that I've noticed is all of your people who are supposed to be constitutional lawyers did not study the Constitution. They only studied what other judges said about the Constitution, thus making that judge the law and not the Constitution. Thanks for watching. I hope this helps.